I'm Laura Farley, Associate General Counsel with the Virginia Association of Realtors, and I want to welcome you to another edition of Legal Hotline Q&A. This is the second part of a two-part series on new laws that are taking effect on July 1st, 2015. And the focus of today is just some of the highlights to property management. Every year there's lots of changes to the VRLTA and to landlord-tenant law in general, so I would encourage you to find a class that covers all of them, because I am just going to give you some of the highlights, and there are certainly more changes than I've got time to cover today. I'm going to start with changes to the VRLTA. The first one deals with when there's visible evidence of mold. The landlord is now required to promptly remediate and reinspect the property if there is visible evidence of mold. And then in that reinspection, confirm that there's no longer visible evidence of mold. And as part of that change, the tenant is now entitled to view any documents that the landlord may have regarding that remediation, so that the tenant is able to see that it was properly remediated. The second change is it talks about when a landlord or a manager can photocopy ID as part of the application. The law now references the federal law and says that in certain circumstances, photocopying certain IDs may be prohibited by federal law. So the law now here in Virginia says that you're allowed to copy an ID unless otherwise prohibited by federal law, and it references that federal statute. Another thing deals with prepaid rent. It now says that the landlord and tenant can agree in the rental agreement to prepaid rent. Previously, it said that the tenant could offer and the landlord could accept. Now it's clear that it can be either side's suggestion. Another thing is with confidential information. Any confidential information can be released from the landlord to a property manager and to a subsequent property manager if somebody else takes over. And it also says now that the landlord and that property manager can contract with a third party to store those documents electronically or in another media. And if something happens due to a data breach from that third party, the landlord and the property manager won't be held liable in certain circumstances. The next change is that if there's no forwarding address for a tenant who is owed security deposit or other money back to them, after waiting the 45 days plus 1 year, the landlord shall, in a reasonable time, but no more than 90 days later, send that money back to Virginia, and then it gets incorporated into a housing fund. So now keep in mind that it's got that extra requirement about reasonable time, which is defined as no more than 90 days. The next one talks about in non-emergency situations when the landlord has to have the tenant move out to do remediation of some kind or repairs of some kind to the property. There is a requirement that landlords give at least 30 days notice before the tenant is required to move out in those non-emergency situations. And the law is updated to say that both the landlord and tenant can agree to less than 30 days, but if the tenant doesn't agree, the landlord can't require the tenant to move out in less than 30 days. And finally, on VRLTA, fire or casualty damage, the landlord can terminate a rental agreement by giving 14 days notice when there's fire or casualty damage, and that's down from 30 days, which is what the previous length was. There are just a few changes to the landlord-tenant law generally, which applies to all landlord-tenant situations. And one of those is if there's a change in use of the property, the tenant, you cannot waive that 120-day notice. It's now very clear that if you're in a 1 year or longer lease, there's a minimum of 120 days notice before you can have the tenant move out. Now, if the tenant's on a month-to-month, then it's just a 30-day notice because they're on that month-to-month. The second change in landlord-tenant law deals with submetering for energy, sewer, and water, and it now applies to manufactured home parks. So it's just adding one more category that those cover. And the final for landlord and tenant is that a family trust has been added to the list of entities able to recover rent or possession of the property. So it's just making sure that every category of entity seeking rent or possession is able to do that. There are two changes that are much broader. In the VRLTA, under the retaliatory conduct section, the person alleging retaliatory conduct no longer has to prove that it is the primary reason for the termination. They still have to prove that there was retaliatory conduct, but the courts no longer have to find that as the primary reason for termination. And that was already in VRLTA, so they just changed that. And then they've copied that entire section into the generic landlord-tenant law. So it's now in all situations. And then the final change I'm going to talk to you about today deals with unlawful detainer. And it says that if the defendant fails to appear, the plaintiff can submit evidence. And now it says that it's either an affidavit or testimony there at court of the outstanding rent and other damages that are due. And if the lease requires rent to be paid in full due on the first of the month, that the entire amount can be due at the hearing for that month. So for example, if the hearing is on September 5th and the lease calls for the full rent to be due on September 1st for all of September, they can ask to have the entire month of September as part of what is owed through the court system, not just those first 5 days. But you got to remember that's got to be requested in order to get that full month. And the last thing that goes under that as well is that a creditor must note satisfaction of a judgment only when it's been paid in full. So if there's partial payment, the creditor doesn't have to note satisfaction because it hasn't been paid in full yet. All right, everybody, check out VAR's website for more on the new laws taking effect July 1st, 2015. Thanks, and have a great day.